supplémentaires. Oui, c'est vrai que
Good evening, ladies and gentlemen. My name is Ulad Belavuso, and this month I have joined the ASA Institute as a senior researcher in European law. And I joined the institute with the project on the study of the so-called memory laws, basically various ways the law governs history. So it's a big project involving PhD postdoc researchers run for 3 years with the ASA Institute. And this lecture fits very much into this paradigm of law and history, and we have three exciting speakers for today. So this is the second in the row of supranational criminal law lectures meant for the season 2016-2017 at the ASA Institute. The ASA Institute has been running them since 2003 in cooperation with two partners. One is the Leiden Center Grosser Center for International Legal Studies based at Leiden University, so it's not surprising in the audience we've got lots of students from Leiden University, and with the coalition of the International Criminal Court. Moreover, I should say that within ASA we have two research strengths where this presentation, this lecture fits perfectly, namely strength A on human dignity and human security in international and European law, and strength C on adequate dispute settlement and adjudication in international and European law. So tonight's lecture is entitled Mass Atrocities Trials as a Tool to Control Historical Memory. And without further ado, let me introduce you our outstanding, I would say, speakers. So the first in a row would be Gordana Knežević. She's currently the general editor of Radio Free Europe, who became really famous with her various highlighting of the siege in Sarajevo 1990-1994. Then the floor will go to Sir Geoffrey Nice, who actually was the principal attorney in the ICTI when prosecuting Slobodan Milošević. And finally, the floor will go to Dr. Nevenka Tromp, who is a lecturer at the Department of the European Studies of the University of Amsterdam, and an author of an outstanding book published with Routledge, actually, on the trial of Milošević. So without further ado, let me give the floor to Gordana. Thanks.
Thank you very much for this introduction, and thank you for organizing this event. This is, for me, an amazing opportunity to be here and to share with you some of my experiences. First of all, I would like to say what is connected three of us. What is connecting Sir Geoffrey Nice, what is connecting Nevenka Tromp, and what is and myself in this, and how we came together here. In a way, it is. I'm from Sarajevo originally. I'm a journalist. I used to be a journalist at Sarajevan daily newspaper Oslobođenje, and I covered the war. So when it comes to Milošević, I lived under his regime and I survived Milošević. So Mr. Jeffrey Nice was the most important person in bringing Milosevic to justice. Unfortunately, that trial was not finished, and an amazing book about this unfinished trial was written by Nevenka. So that is how three of us came together tonight. I would like first to express my gratitude for being here for the first time. I am at the Hague Tribunal, and it was very, very emotional for me, and the only thing I wanted to see this morning here was actually the tribunal itself. I did see the town, but that was secondary thing, like for me, because tribunal is the place where people who shaped my destiny and who shaped the destiny of my country actually were charged and some of them got verdicts, some of them are expecting verdicts. I would like to remind you how hard was the road to get to establishment of this type of the court. In 1992 in Sarajevo, the first person who came during the winter, it was winter 1992, I think it was December, and a person who showed up in a wartime city besieged and in a very difficult, the city which lived under very difficult conditions, it was Ari Nair from Soros Foundation. He came and he was giving workshops to Bosnians, teaching them how to make records and how to make sure that the war crimes committed in Sarajevo are being that each crime is being recorded and the proper evidence is collected. I remember people gathered in a building, an old Austro-Hungarian structure. There was no heating. There was no people sitting in their coats. Ari Nair was in his coat as well, and he was giving instructions and telling people, please, you have to write down for each shell at what time exactly it fell down, what damage was done, what happened afterwards, how many people got wounded, how many people got killed. You have to have names, you have to have all this collected and on. And at that time, at that point in time, to think about that there would come a time when these people would be asked for their responsibility about the crimes and to be accountable. It looked like science fiction. It didn't look real, because at that time there was no even talk about an international tribunal. So in that sense, I think if Ari Nair didn't come to Sarajevo, I doubt that there would be much evidence about what happened, particularly in these first years of war. So, and I, as far as I know, I don't even think that his work was ever recognized or mentioned anywhere. But just being today at the Hague Tribunal, I was just thinking how long was the road from that lecture in a wartime Sarajevo to see a full-fledged tribunal, which is actually now close to be, it's a tribunal which is now closing to its final sessions and to its final verdicts. I'm very privileged to be here with people who did the job and who worked for International Tribunal, and there is, people believe at least, that journalists are writing the first draft of history. I don't know if I trust in that completely. At least when you are a journalist, particularly when you are covering the war, you are not thinking of history. You are just trying to be accurate, and you are trying to do it. You are doing it for your readers, and you are doing it for that day, and you think that what you produce has a value for that day. Not, I even don't think that if a journalist would think of history, I think that journalist would be scared to write anything on a daily basis. But anyways, that's what many people believe. In that sense, I think that Tribunal actually is making judgments which are shaping history and which should be shaping history. I would like as well to quote a French historian, Ernest Renan, who said that getting history wrong is an important part of being a nation. So if Renan is right about history and nation, then I can say that what we have in Balkans, we have great nations, because they are doing a great job in getting history wrong. It can be said of mainly about Serbs, but as well about Croats and about Bosniaks. There is almost a kind of competition in Balkan countries, who is bigger victim of the war when it comes to war from 1992 to 1995. There is each and every nation would like to see itself as being a victim. Nobody wants to admit that his national group did some wrong and did some crimes. And in that sense, like I very often ask myself why the Hague Tribunal didn't have bigger influence on shaping the historic account of events. Why it didn't connect better to people on the ground? Why it didn't have bigger impact on what is happening in the region? Dominant opinion in Serbia and Republika Srpska is that the Hague Tribunal was established to go after Serbs. Serbian politicians and media would refer to it as an anti-Serb institution. Croats don't have much enthusiasm for the Hague Tribunal, as they feel that the heroes of homeland war were unjustly indicted, because they consider that it is pro-Serb tribunal. In Bosnia, where most crimes happened and where people should be most interested in international justice, there is a feeling of resignation, of hopelessness and mistrust. They consider the Hague Tribunal slow and ineffective. And the other thing which I noticed with my fellow Bosnians is that most people in Bosnia think that what happened is so terrible and so obvious, and what is there to be researched and what is there to be proved. They are not seeing the point of entire process of establishing facts in a way in which it is done at International Tribunal, in particular at the Hague International Tribunal. But on the other hand, the tribunal didn't manage to persuade people in former Yugoslavia that their conclusions and sentences are depicting real events. It didn't contribute to reconstruction, reconciliation. And I mean, many people would argue with this and would say it's not what the court is about. The court shouldn't contribute to reconciliation. But people trust the Hague Tribunal decisions only if they are in line with their own prejudice and beliefs. So whatever decision is not in line with prejudice and beliefs, that decision is being rejected and seen as unfriendly, as unfair, as biased, as this or that. And the question is why the Hague Tribunal didn't achieve to be trusted and respected. Most people in Serbia did not experience any war crime. They didn't see Srebrenica killing fields. Any information they get is through media or by politicians. Some sources are being easily dismissed. For example, we have in Belgrade a Center for Humanitarian Law. Many of you may be acquainted with the name of Nataša Kandić. She's doing an amazing job in collecting evidence on war crimes, and she's doing and she's collecting evidence on war crimes committed in Kosovo and in Bosnia and in Croatia. And I cannot imagine a person more devoted to this cause than her. But in Serbia, she's seen as a traitor, and she's being disqualified by media as well. People say about her, well, she's receiving funds from foreign governments and from foreign sources, so she must be foreign agent. That's how her role is seen in her own country. I mean, it's she's even being discriminated and mistreated by her own neighbors, and they think that she's being undecent person because she's bringing like dirty laundry of her own nation to public, and all kind of things are told about Nataša Kandić in Serbia. ordinary people were not reading the Hague files. Media and political elite in each Balkan country are playing a crucial role in interpreting the Hague decisions. They have responsibility for misunderstanding of the way how international justice works. Finally, it is easier to believe that the Hague is an anti-Serb entity rather than that some people of my own ethnic group committed the most cruel crimes. So it's as I had personal interest in this issue, and I was looking, is it only in Balkans? Is it just in my country that things are so bad and that people are not capable to accept decisions by an international court and so on? And so, but I think that this is actually not so unique. This thing is happening elsewhere as well. For example, I was thinking even nowadays, people in Japan wouldn't accept that they did anything bad during Second World War. And there are other places where people, when it comes to collective memory, where people are like suffering of collective amnesia when it comes to uncomfortable truths, and when it comes to have a good record and a good knowledge of events which took place in the past. As I already mentioned, each ethnic group in former Yugoslavia is seeing itself as a victim of the war. To make them believe and accept the truth about role of their own people in last war is almost mission impossible. It's very often mission impossible. It is as hard as to persuade people who don't believe in evolution that Darwin is right. To expect that at some point that the Hague Tribunal files will shape historic narrative in the Balkan countries is not for the time being realistic. Even if the tribunal was 10 times bigger, even if it was 10 times better than one we have, and one we have was making mistakes and was providing arguments to people who wanted to discredit it and to dismiss it as political court. I just would like to, however, I think it is still early to have a verdict on the Hague Tribunal. Very often I'm asking myself how Balkan would look like if there was no Hague Tribunal. Probably Karadzic would still be president of Republika Srpska. Praljak would be mayor of Mostar. Milosevic probably would withdraw from power in favor of his wife Mirjana Markovic. The Hague Tribunal didn't manage to change Balkan countries, but it did repair the post-war ambient. It did help the post-war situation in Balkan countries. So I as well would like to mention that what is problem now and what is working against this possible influence which the Hague Tribunal could have on historic narrative of the wartime events. Education is a big problem. Nowadays, kids in former Yugoslavia are being just told that things happen differently than they happened. For example, in Serbia, the kids are learning that there was 11 genocide in history and that all these 11 genocide were genocide against Serbs. There is no accurate account of what really happened in history. I had a brief look at history textbooks in Bosnia and in Croatia. They are not doing better job. It's terribly one-sided, and the basic facts of the war of 90s are missing in these history books. In that sense, I would like to stress how much books on the Hague Tribunal and of these trials are important, and how much they actually, I believe that the books will help to shape historical narrative, because I cannot imagine that ordinary people would go and search files, and it's not possible to go through thousands and thousands of pages. So somebody has to make this readable and digestible. And in that sense, I would like to mention, for example, the book written by Julian Borger from Guardian newspaper. He wrote recently a book, The Butcher Trail, How the Search for Balkan War Criminals Became the World's Most Successful Manhunt. And I think that's one that's one great book. The other one, which I as well think is very important for the future and for the history, is definitely the book written by Nena, who will talk to you later on, Prosecuting Slobodan Milosevic, Unfinished Trial, which I think gives a great account of and gives us a great idea how this trial would actually end, if it did have an end. And the reason why it is extremely important to deal with these issues and to write about these issues is related to the fact that now, when we are 20 years away from wartime events, from war, there is more and more attempts to rewrite history and to change the narrative about wartime events. The latest attempt is happening actually just these days. There is a kind of new group of new international experts. I still don't know all the names involved in this international experts, but they are organizing a kind of experiment in Nikinci. It's a place in Serbia. It has a military military exercise grounds and stuff, and they are going to recreate Markale massacre, which happened in Sarajevo. The first one happened in February 1994, and the second one happened in summer 1995. They will recreate, they will make a market, and I don't know whether they are going to make the hills around Sarajevo and what else they are going to make there. And they are bringing these experts to show that it is impossible that the shell which killed people at Market massacre came from Serb side. At the moment there are a number of other attempts to change the narration of major war events, and in that sense, like people who witnessed these events are not around anymore. They are not there, and I just think that if journalists and academics, if they don't react and if they don't correct these attempts to rewrite history, I'm afraid for the future, because I believe that a future and well-being of a nation depend on its capacity to face truth and to face the real events. Thank you.
I shall be brief, and I shall really be little more than a runway to take off for Nena Tromp, who I'll introduce in a little bit. And even then, much though she has to say, we'll have plenty of time for question and answer. But don't feel inhibited if you want to interrupt me and ask me something as we're going along. I'm just going to give you a few general thoughts around this topic before I sit down. And perhaps I can start with this. When I came to The Hague in 1998 to prosecute at the ICTY, like any other lawyer really, my job was to try and handle a massive evidence. It wasn't the Milosevic case then, and to try and get the best account from that evidence of what happened. I wasn't particularly interested in getting convictions in themselves. That always seemed to me a slightly questionable motivation. I was really interested in seeing what the evidence could reveal, and then if the evidence was good enough, then the judges would convict. I came back and led the Milosevic trial, and in that trial in particular, things started to become slightly troubling, because it was very obvious to me that there were occasionally bits of political pressure on the court, and in particular on the prosecutor, to corrupt the result in one way or another. And of course, as the lawyer, you had to, when you knew about it, you had to fight that off and try and leave a clean record. And that sort of thing irritated you a bit. or more than a bit. And of course, if the trial had been corrupted, then we've lost the title because we got the title of my few slides. But if the trial was corrupted, then to the extent that a historical record is dependent on a good record of the trial, then the historical records become a bit corrupted. Well, when Milosevic died, I left and I turned my mind to other things, and the particular problems of trial, individual trials being corrupted, perhaps ceased to worry me less. And as I looked around, am I doing something wrong? I don't need anything yet. I'm a very happy chap. Oh, there we are. Oh, that's it. Let's go back one. We don't want him yet. Let's go back one.
Yep.
That's fine. Absolutely perfect.
I thought you would be going back to Burst of Christ and disappointing now.
No, you're going to be doing that, I have no doubt. And I started thinking really about getting involved in other things and thinking about other things. And I became much more aware, or I became aware, I suppose, of the much more general gap that there is between what the public expect of legal processes and what legal processes deliver when they deliver anything. And of course, sometimes the gap between expectation and delivery is not just the gap that might be between what, for example, Bosniaks might have expected from the Yugoslav trial in respect of Srebrenica, but what people, for example, the Rohingya Muslims of Burma, might expect of a judicial or juridical response to their suffering by the world at large, when the world at large will do nothing. And why will it do nothing? Tell me. In Burma. Well,
It's simply because the United States of America and the Western allies, they are simply trying to sign MOUs with the Myanmar government because of their China policy and the whole region.
absolutely. And also it's become a tourist destination and it's got lots of lovely minerals. So the expectations in a judicial response from the Rohingya Muslims, which at one time was quite high on the Foreign Office's list of interests, you could go there and they'd say, yeah, what a good idea, let's take them to the International Criminal Court. You go there now and they say, no, awfully nice holiday resort, goodbye. Or North Korea, which is, I think, where I was last in this room, and we were successful, some of us, not us, but we helped those who were successful in getting a very strong resolution from a commission of inquiry for the Human Rights Council to recommend sending North Korea to the ICC by way of referral. But wiser councils have now said, no, not yet. Or other cases, going back in time, the Iran massacres of the 1980s, no one will think of trying to expose the present and successor Iranian regime to the Ayatollahs to judicial intervention, or going back still further, for those of you who can either remember it or who've read about it, there has never been any kind of judicial intervention into one of the greatest war crimes perpetrated in the 20th century in Vietnam by the Americans. So it becomes very clear as you start thinking around this subject that the naive, the optimistic, the willful belief in the public that the law is going to do something for it is something you've got to be a teeny bit careful about. Not just in the individual cases, but much more generally. There's this big gap. And that also led me, I suppose, over time to appreciate that in the business of persuading people that legal processes can be relied upon to tell history, which in fact is what some people are doing, and in particular the Serbs are doing, and in some ways, and we'll come to another example towards the end, there is an investing by all of us, particularly the lawyers. Never trust lawyers too much. Keep them to their post. don't trust them outside the courtroom, then they're not elected to do anything, and they're often very ignorant. But lawyers will have you believe that what's going on here in The Hague, at the ICTY and the ICC and everywhere else, has got a huge, long tradition and a lineage. You know, they say, oh, yes, you can find war crimes trials. There we are. William Wallace, 1270, butchered in 1305, and it is true. They read the indictment to him, but they didn't allow him to speak before they hanged him, drew him along the streets and carved him into nasty little bits. It wasn't a crime, it was a political act, dressed up with a court process to give it some kind of respectability. And then, there he is again. And then there's this chap, Peter von Hagenbach, which people now rely on very much as a first war crimes trial. He was seen off. There's his trial on the left, and there on the right is a picture of what inevitably happened to him. He was taken along in a tumbril, and his head was cut off. He was a supporter, I think, of working for Charles the Bold. And if you look into the history, yet again, this was probably a predetermined trial with a known outcome, and it was a political act given respectability by due process, or undue process, I suppose. And then, of course, poor old Charles I of England, there he is being tried in 1641, and there he is being dealt with after the trial on the left, with, I think, for those of you who can see it, with the head being held up, job done on the right. This was another apparent trial, but it was achieving a political result. And you've got to ask yourself, as you think, well, can we look at trials as a reliable way of telling history? And we say to ourselves, with this long lineage, are they actually still completely free of being political events dressed up sometimes in the form of trials? Well, we know that by the time you get to the First World War and the Second World War, the answer to that question is pretty firmly, they're not really to be trusted that much, because they were always one-sided trials. There was no trial of the other side. So the trials themselves may have been all right, but as to telling a complete story, of course they never did. So there's a gap between public expectation and what the law delivers. And the law gives itself false credit sometimes in the international arena, so that we have to be very, very careful, I believe, about what the law does. Now, I think the next thing I'm going to do is ask you to do something completely politically unacceptable, improper. So you mustn't speak. Here, can you read them? There's a list of names. Now, just look at them and think to yourself, do I hold a view adverse in any way to any of those identified groups? I think they've all been in wars. Just think about it. Do I actually think that group is more likely to be a criminal than that group? Because if you do, ask yourself the question, why? For example, I sometimes sit as a judge in England. Very respectable people, judges, sitting around the lunch table. They try hard to be fair, you would think. And you can hear them say, even now, of one of those groups, and I won't say which, they're all crooks. And that's because they have tried some of them. And the process of a trial, acquitted or convicted, and how the trial is a very, very powerful piece of memory. Nothing more so than these two images. Is there anybody here who doesn't know what they are? And what effect have they had as the most, certainly this one, not, yeah, that one or the next one, is it? I think that's one. That one. Almost the most memorable image of a certain war, and an image that you may think, because of the trial, has had an immense effect on the way we all think about a certain nation, or have done, and dangerously. So, in my own personal approach to these problems, and I'm going to finish and come back to a specific example very soon, I think courts, which do terrific work, there's no doubt about that, are in many ways remote from the expectations of the individuals, and you've got to be really careful about the power that they have. At the ICTY, there have been many judges over the years, some of them really bad, shocking, and some of them really good. And that's not me, that's you. Where's me? You've taken my slide away. Have you really taken my slide? Never mind. See if we can find it again. It's gone. But I can read it to you from somewhere else. It won't take me long, and I can find you a quotation from, at least I think I can. I can find you a quotation from Judge Patricia Ward, who tribunal watchers such as Mirko Claren sitting at the back there will remember, and I hope he will agree with me, that she was one of the universally respected judges, came from America, very senior woman judge, and she summarized, if I can find it on this version of things, if I can't, I shall have to give up and move on. But she explained that in the early stages of the tribunal, there were great expectations for what it could do and how it could do a great deal more. Here we go. I'm sorry I'm going to have to read this to you, but something went wrong with my slides. I'm never very good with machinery, and I probably pressed the wrong button. She said this: initially, the tribunal was urged to make detailed findings about the social and political etiology of events leading up to the atrocities on trial. This, it was suggested, would provide an antidote to revisionist history by preserving adjudicated accounts of what actually happened in the foreplay to the Bosnian conflict. As a result, dozens of pages in ICTY judgments focus on the causes and precursors of the 1991 outbreak of hostilities. However, commentators, citizens, and officers of the implicated countries increasingly suggest that the adversarial trial process, and I imagine you all know what an adversarial trial process is, the adversarial trial process and the findings of the judges may not produce the best approximations of history. Moreover, and she goes on to say, I haven't got the end of the quotation here, but she goes on to say, and it's a very powerful point, how could their versions of events be good for history when the states involved themselves do not take part? And so she says, basically, what I felt when I came in 1998, look at the case as it is, try and do it as well as you can. If the chap's guilty, the evidence will show it, but don't look to be doing a greater task than that. One example before I introduce Nena in a bit more detail. I've said at the beginning that we were aware in the Milosevic case of pressures on the court from one source or another to corrupt the process, to call this evidence, not to call that evidence, to indict this person, not to indict that person. And we did judge this to be both national interest, and later on, I suppose, and looking back, we thought, yeah, this is actually an attempt by that country or this country to rewrite history. For example, if Serbia was instrumental in getting Haradinaj, the Prime Minister of Kosovo, indicted, well, then it begins to equalize the culpability of Serbia and Kosovo. But the example I'm going to give you comes not from one of the warring states, but it does relate to Srebrenica. And it relates to the fact that in July of 1995, just as Srebrenica was about to happen, we know without any doubt that Milosevic was on the phone to General Mladic, whose trial is coming to some kind of conclusion and who is generally regarded as completely responsible for the Srebrenica genocide. Not only was he on the phone, but we knew that there were intercepts of the phone calls. So we wanted the intercepts. I hope you think that was a reasonably responsible thing for me to do, backed up by Nena, who was the principal researcher and who knows more about the Milosevic case than anybody else on the planet. And so we went to try and get hold of the transcripts of the intercepts, or the intercepts themselves. And you would think, wouldn't you, that that would be a good idea, because it would tell us more about what Milosevic knew and what part Milosevic was playing. And was he contributing to the genocide? So what do you think happened? Of course, I can't tell you what happened, because somebody take me out and shoot me. But I can let you know in essence what happened. A body, shall we call it the international community, or a representative of it, came in and stopped us, even seeking to get the intercepts. Why do you think they did that? Was it because they didn't want us to know what Milosevic was doing? I doubt that. The only reasonable excuse I can give, or not excuse, just explanation for what happened, was that the international community would rather we, the public, and Bosniaks, the victims, would remain ignorant of a crucial detail of what happened, rather than they and the world should know how much the West knew, and therefore how much additional responsibility might have fallen on the West. And so that's another example of the gap about which we have to be careful in consideration of using war crimes trials for the purposes of history. But the records of evidence they leave are sensational. People speak who never would speak. Documents are produced that would never be produced. And it was curious that when the Milosevic trial ended, the court seemed to want to have nothing more to do with it. No verdict, no interest. Well, Nevenka Tromp had and has a couple of extraordinary advantages in life. She doesn't like lawyers, that's a good start. But she happens to have legal skills, which she doesn't particularly want, which includes being able to see an event in that field of research or records or knowledge and see its connection to an event over here, either to show that the two are compatible, or when dealing with assertions made by Milosevic that they're incompatible and that the account he, or more likely his witnesses, were giving could be shown to be false. And she was not prepared to let this extraordinary resource remain effectively inaccessible. And so she wrote a record of the unfinished trial, standing back, reaching some surprising conclusions, built on the fact that she had supreme knowledge and extraordinary strength of memory and that wonderful ability that lawyers all wish they have, most of us don't, to connect things from all sorts of different places in order to show the truth. So I think it's time I let her speak.
Thank you, Sir Geoffrey. And you know, when I started to work with Sir Geoffrey now about, 10 years ago, one of the things he told me at one of our first serious meetings with the ex-president of former Yugoslavia was never to overstate anything. So the fact that he's overstating every single position about my role in the Milosevic case only evokes my distrust in lawyers, because I'm now trying to figure out his motives for that. He taught us, because he told me and taught us, if you understate your case, if you go down, down, the only way you can go is up, up. If you overstate your position, the only way you can go is down, down. So I'm afraid I'm going to let you down. There is no other place for me to go. To show you how no lawyer works at a criminal trial, not understanding a lot about the law, but believing that common sense is the best methodology in every possible profession in the world. What happened in last August is I was sent an article written by Gordana Knežević, whom I, of course, in my general ignorance, didn't know. And even if I had read anything from her, I didn't bother probably to see her name. It was a short article, but you know, one of these things Mark Twain would have written very gladly, because he always said, I have no time to write short articles. So this article was one that captured so much of a very difficult truth that we, working at the tribunals, and especially at Milosevic case, came to know by hard work and sometimes too much work for very little result. What did she say? She quoted two foreign observers, commentators, who were using the judgment, ICTY judgment of Radovan Karadzic, rendered in March this year, and saying that in a particular paragraphs of the judgment, the court actually exonerated of any criminal responsibility and Slobodan Milosevic and the state of Serbia. And she quoted and drew to our attention a quote of Ivica Dačić, the current Serbian foreign minister, who started his career as a very junior politician during Milosevic's rise to power, still leading the very same party Milosevic started in 1990 as very important instrument of his power. So how the connection was made? First, I had written a book about Milosevic trial, having in mind several things, that I worked 6 years at this trial, day and night, sometimes in the weekends, and when he died with no judgment, and when lawyers at the ICTY suggested that we should all forget about this case because there was no verdict, so it was basically useless, my common sense again told me that it's impossible that the work of me as a single person plus 100 of my colleagues in a different profession is wasted and could be wasted just because there was no judgment. So I tried to make sense what is actually value of a trial or trial archive of a trial that did not finish in a judgment. So it was a long journey, but I would like to bring you through some of the propositions, and inevitably I will deal with the title of our lecture, which will explain to us that unlike the expectations of most of us liberals here in this room, that mass atrocities trials will contribute to exposing and understanding the truth of the conflict, the opposite could be the truth. There are different ways how during the trial process different actors and parties can interfere to influence the trial record. And in my understanding of everything, I will actually go back to several things that and Gordon and Jeffrey already said. The legal system known as adversarial system, where you have two parties engaged in some sort of football match, trying to score goals on each side in each part of the trial, there are inevitably at least two truths that these trials can produce. But what I will never forget, engaging in this sort of debates with Jeffrey at the time that we worked for the Milosevic trial, he told me the following: you can prosecute a case in an adversarial system without having truthful facts on your side, and defense can defend without using truthful facts. So you can win the case, you can render justice with no sides being close to the truth. And it made me think, what am I now supposed to do with the immense record of Milosevic trial? It was thousands of pages, millions of pages even, documentation, audio material, and video material. So first thing what I did, and the quote Jeffrey read for you by the Judge Patricia Wald, it said something about helping revisionist histories. Well, you know, if you say helping to correct revisionist histories, you at least have to know what this revisionist history is. So my first step was to go to the historical literature on the demise of Yugoslavia and the role of Milosevic to see what sort of views, historical interpretations already existed, and what this trial record of this particular person contributes to this whole debate. So it was an approach from quite abstract and umbrella position. And I identified three approaches. One was relativist approach. And this relativist approach says, yes, Milosevic and Serbia were very important in disintegration of Yugoslavia and violence that followed, but they were not leading the way. They were reacting to other republics and other actors involved. And according to this interpretation, which is, to my survey, the dominant one, Milosevic up to 92 indeed wanted to preserve Yugoslavia and was fighting for that, while Slovenia and Croatia wanted to go separate ways. And the clash came about because of these two opposing roles. The approach that Milosevic trial record exposed or was dominant while researching his particular trial case was intentionalist approach. And this is approach that I took gladly from the historians who studied Nuremberg trials. And after trials were finished, historians who went into trial records wrote or constructed a historical interpretation that was focused on political and military elites and their intentions. And for many decades, this interpretation was dominant when it comes to the importance of Nazism and the consequences of their rule and the war. But even that intentionalist interpretation came under scrutiny because a British sociologist attacked it and said we need to understand that part of the past by a functionalist approach, to understand why others, why common soldiers so willingly went and did the job. And so relativist approach and then intentionalist approach, where my book actually and the way I was drawn to this huge historical source probably would fall under. And the third the apologist. These apologists, I identified at least two authors, and they are both from Serbia, Serbian authors, and they say the following: well, Milosevic was a little bit wayward. He didn't really win a lot. He lost things. He was too much under influence of his wife. But actually, we have to cherish him historically because he stood up to the whole world and international community. So when I read Gordana's article and the way how Ivica Dačić interpreted Karadzic's judgment, it immediately fell under this apologist interpretation. And then when we go back to the trials and what trials actually do and tell us, what Dačić did is he represents this double wager, a pitfall of the adversarial system when it comes to the truth, because he was following the logic of defense narrative. Because if you would go to the trial record, just read opening speeches by Milosevic, follow his defense witnesses, you see that whatever was said recently in Serbia about this trial and other trials fits into this mode. So the fact that a judgment comes doesn't mean that this double wager disappears. Judgments will not necessarily give the perfect gray dominant interpretation. Struggle for the historical interpretation cannot be fought between judgments and in the courts and between the courts. Why? Every judgment is fixed in time. It doesn't change. As a historian, you have more daunting task. Every time you get new document or new interesting theoretical work comes up, you as historian move on. You are entitled to change your mind. And you function within academic freedom. You can use sources that are half-burned. There is no forensic truth of proving authenticity of a document at stake. So the responsibility for historical interpretation is not and cannot be put on judges, judgments, and trials. So what is now what led me to write this book? Again, I looked to the work of scholars who studied Nuremberg trial, and one particular scholar actually said that what mass atrocity trial leaves behind for historians is actually a material, an archive which has to be scrutinized, critically assessed, corroborated with many other sources as any other historical source. And this was the starting point for that. But another level of my analysis came one step further to the detail. Reading the literature on transitional justice, I came across a book, Transformative Trials by Leora Bilski, where she analyzed political trials in Israel and actually said that mass atrocities trials are political trials, not because they are show trials, but because they deal with political issues. And by addressing a serious political issue, crime, in this sort of form, you expose them to public scrutiny or knowledge. And I took this notion very seriously, and I went to Milosevic's trial and deconstructed it, identifying transformative trial evidence. And one of the transformative trial evidence, which I can gladly use now for Dačić, is following. When I read his name in Gordona's article, I immediately remembered this exhibit in Milosevic trial. It comes from an obscure journal called Epocha, published by SPS, Milosevic's party, and it was not that well known. I got to know about it in 2000 when I came across this map. We got only this picture from a scholar who wanted to help us with evidence in Milosevic's trial. And by pure chance, because he's a very good scholar, he wrote the name Epocha. So next time I was in Belgrade, I went to National Library of Belgrade, and I asked the librarian, please, can you give me all numbers, issues of Epocha you have? So they gave everything to me, and this map was actually attached. It looks like this in evidence, but we also exhibit it like this. And it was an article published on 7 January 92, an article so interesting because it was written by a young coming star of SPS, sometimes called Mali Slobo, Little Slobodan. And his name was Ivica Dačić. So transformative value of trial evidence is such that you don't need to have overall picture whatever happened in Serbia, but you would have access to immensely important pool of historical material that, if not for the trial, would be completely forgotten, because Epocha was not an art magazine someone would buy and read at home. So why is it important? This article we used in cross-examination of many defense witnesses who were intellectuals. Some of them were authors of this infamous SANU memorandum from 1986, which now it's about 30 years of anniversary since it was made public. And an interesting connection that you can see grow from this is that in 1986, when this memorandum was published in a clandestine way, unfinished and so forth, Milosevic never clearly said that he even ever read it. He only never attacked the authors. And in his opening speech at the ICTY, at the tribunal, he said, why are they attacking memorandum and academia? Academia is here to give the worthy opinions about everything. But during the war, most of the authors of this memorandum were his advisors. 3 or 4 of them became members of main board of his party. And at the end of the war, they came to testify on his behalf. And then this particular map was so important because it depicts the whole Yugoslavia, and all these little circles are municipalities. And in the middle you have Bosnia and Croatia. So these are Croat municipalities, these are municipalities in Bosnia. And they are planning to have a third Yugoslavia. And they hope to have this third Yugoslavia with the western borders somewhere here. And for us as a prosecution, that was one of the little steps to show how premeditated the actions of Serbs were, so that they were proactive in doing what they were doing. And one of the passages from article written by this same Ivica Dačić, who now says that Serbia is exonerated, is all debatable territories should be put under the protectorate of UN and blue helmets, in this way, a better protection may be provided for Serbian people in Croatia against the aggression of the Croatian army, and at the same time create the possibility for population to declare about their new state in 5 or more years. In 90% of cases, the territories that had been under UN protection sooner or later got the right for independence. So for you who have no idea what happened in Yugoslavia, at that time UN protection forces were in Croatia, and their calculation was get the territory, bring UN in, and in all cases in the world, after 5 years, these territories remain in the hands of the nation that populates them. So this was a wonderful moment to show why and how trial archives could be immensely important historical record, and that they still can have and will have important function in transformative way, changing or contributing to understand and deepen the knowledge about the wars and interpretations and historical interpretations. I think I will finish here.
Tell them what the drift of the memorandum was, to which this then becomes consistent. No, you tell them.
There are many drifts of
They need to know that it's a criminal, that it can be seen as a criminal act.
Oh, this. Well, I hope that we might talk about it during the Q&As, but in establishing, there are many different aspects why history is important in a courtroom. There are many people, and I think Anne Jeffrey and Gordana said that courtroom should be for law and the lawyers. However, when one indicts a political leader for a period of time of 10 years over 3 geographical areas, then it's very important to understand mens rea from historical point of view. Milosevic did not invent Serbian nationalist ideology. So you do invite history in the courtroom by trying to understand mens rea, criminal state of mind. And while doing it, we approach to his criminality from the point of view of developing criminality. The question was Milosevic a criminal or intended to be criminal already in 1990? And memorandum does help, and all these maps, to understand at which point they hope to achieve all these territorial gains without violence, and which particular moments were there that they used violence and knew that all these steps that follows would be violent and against all laws. And memorandum was such an interesting issue because we as a prosecution did not pay so much attention to it. Witnesses brought it in the courtroom. And then Milosevic started calling all these witnesses who were authors of memorandum. And one of the fascinating things was that they claimed that it leaked without their knowledge, and that they were surprised and embarrassed. And then in one of forensic ways to show what place memorandum had in developing elitist approach to the crisis, we showed them the leaked version of memorandum and their official published version of memorandum from '94. And we analyzed it, my team analyzed it, and we found only 4 minor changes. And we asked one of the major authors of memorandum, it's almost the same, so why do you keep saying that it was unfinished? And they basically, several of them said, yes, the changes were minor. And then we claimed that they, on purpose, created this sort of aura of secrecy, so that memorandum became immensely attractive to everyone. And by spreading it in this clandestine way, they were actually paving the path to this nationalist ideology and mobilizing masses for it. Was it what you wanted? No? Okay. Thank you very much.
Many thanks for our speakers also for keeping it perfectly on time. And now we've got time for questions and answers. My colleagues will collect them with micro. I suggest that we go this in rounds, so let's collect 3-4 persons their questions and then address them to 3 speakers. Who wants to be the first? Please.
Good evening to everybody. My name is Khalid Ahmed Chaudhry from International Human Rights Commission. We all heard the stories. It's quite painful listening what has happened, and still the things are going on. Sir Jeffrey, I salute you for your work, for your words, for your courage, and also the ladies as well. It wasn't possible without extraordinary courage and intentions to bring, to talk about the truth, but truth. Sir Jeffrey, you mentioned about Rohingya issue. I have been raising all the time, but I can tell you that I could not listen even from the policymakers here in Netherlands over the Rohingya issue. Right now, Kashmir, where more than 1,000 Kashmiris have been blinded as India is using pellet guns. Women are being raped. Thousands are being tortured. No one speaks here in Europe because it's not interested issue. Another Muslim country, another ongoing painful situation, occupation of India. My question to you, Sir Jeffrey, when will be the time that the international community, the question you were raising, international community, including the policymakers, will ever realize that we will have to talk about these issues which are right now going on different regions of our world? Thank you very much, sir.
Anyone else? I think you were also there, yeah. Could you please also kindly introduce yourself first?
Yes, my name is Thomas Verfuss. I'm a journalist following the work of international courts, and like several other persons in the room, I have dedicated more than 4 years of my life to the Milosevic case on a daily basis. We have heard many arguments tonight that may make us think that this has been a futile and useless exercise. The OTP could not get crucial evidence. The adversarial trial is not the appropriate methodology to find the full methodological truth, historical truth. And once an ICTY trial chamber makes an attempt to describe part of the historical truth in its judgment, that part of the truth is not necessarily accepted by the communities in the former Yugoslavia, because politicians prefer to retain their own prejudiced version of history. And I should like to recall that in Bosnia, children go to school and have 3 different versions of history books: the Serbian version of history, the Croatian history, and the Muslim history. So there are many reasons to be pessimistic. I'm glad that Nena gave us one very good example why this unfinished trial has been useful. At least it is a useful archive for historians. And I should like one other positive argument for the usefulness to this argument. When talking to politicians, citizens from Croatia and Bosnia, I often asked why it was so simple to mobilize nationalisms in Croatia, in Bosnia, among the Serbs, when there were those separatist tendencies in Zagreb and Sarajevo. And one argument I've often heard being forward is that after World War II, the genocide of the Serbs was not dealt with by the judicial system of the former Yugoslavia. There were some attempts, but then very much was swept under the carpet with the argument of brotherhood and unity that was the dominant ideology in the new state. So the Serb minorities in Bosnia and Croatia thought that genocide might happen again with the same degree of impunity. And that's why there could be so easily mobilized by the likes of Karadzic and Martic. So that, I think, is a second point why one can still say this unfinished trial has been useful, because it shows that at least an effort has been made, in this case, in the 1990s, to punish the most important war criminals.
Thank you very much. Let's collect one more question.
Good evening. I really didn't think at all that I will take a mic. I just arrived in the Netherlands 2 days ago. I'm the Bosnian ambassador, a new Bosnian ambassador, and I was an ambassador to the United Nations. And I was first listening these statements. I was touched. I'm like Gordana, Sarajevo girl, and I was so moved to see here tonight Gordana. And I'm very proud of you, Gordana, like Sarajevo girl to another Sarajevo girl. It was not easy to be Gordana Knežević, and thank you for all truth, what you are writing and staying on the right side and the bright side of the world, I can say. Mr. Jeffrey, or Sir Jeffrey, I know your job. I hope so we will have more cooperation since I'm here. And Nevenka, also thank you for these statements and explanations. I just want to put one small remarks about international community, about justice, about historical truth, impunity. Yes, we have to fight, and each book what is written like this one, or that explanation is coming, it will give us a new page of understanding what's happened. And if we don't understand and say the truth about our past, we will not have real consideration, reconciliation, and we cannot see a further betterness in my region. We have, whatever happening, we have to try, because a war crime, it's a war crime. And someone could die, but it's still war crime. And we have to talk about that. And I will just refer to one thing. What we are expecting from international community, Sir Jeffrey. You remember last year, on 15th of July, on the 8th of July, we are trying to have resolution in Security Council. Resolution on Srebrenica, to say just that it's happened, a genocide in Srebrenica. On the 1st of July, we have commemoration. There was 136 ambassadors, my colleagues sitting, and I was leading that with all signed, and Secretary General, President of General Assembly, everyone say that it was genocide. 7 days after, the resolution didn't pass. One country, of course 1 of 5, put the veto. And everyone is calling, resolution is calling on the tribunal, the courts, everything, but resolution didn't pass. Just because of the political reason, or how is international community creating a new history. I could see that by my eyes that day in UN, in Security Council, the main body of the United Nations. Thank you very much.
Thank you. Now the floor goes back to our speakers. Perhaps in the order we actually started the presentation. So Gordana is first.
Thank you, Mirsada, very much. It's actually great to see you, and I hope to see you afterwards. I would like just to answer one single thing mentioned here, and it's in relation to Second World War and the way how Yugoslavia was dealing with crimes committed in Second World War. I believe that at the time Yugoslavia was doing more or less what other countries were doing. There was no local trials, and there was no local. So there was a kind of this war, which happened in the 90s, helped me to understand what happened in Second World War. This war, which happened in the 90s, made me believe that probably most killing during Second World War was done by my own people. I mean by people in former Yugoslavia. The Germans were there, but obviously the major crimes were committed by Chetniks, by Ustaše, and by this homegrown Nazis, not only by Nazis who came from outside. In that sense, Yugoslavia. But the thing is that, for example, the crimes committed against Serbs were really very well in memory of everybody in former Yugoslavia, not only Serbs. For example, Mirsada can as well back me on this one. There was no child who was not sent to Jasenovac, where Serbs got killed by Ustaše. That was like a common thing to happen to, in whatever school you were in former Yugoslavia, you would be taken to few places where the worst crimes were committed against Serbs. So that was in collective memory of everybody, not just Serb people. But what was not as well never publicly admitted in former Yugoslavia is the fact that the biggest victim in Second World War were Muslims. The only historian who made this record was Dedijer, Slovenian. And he said because he looked proportionally, the percentage having in mind what was population of Serbs, of Croats, of Muslims, and proportionally the Muslims were the biggest victim of the Second World War. But we were not told this in our textbooks. This was not our knowledge of Second World War. So we had. I think this can be Yugoslavia and particular communists after Second World War. They wanted really to look to the future, and they exposed Nazi crimes, and the crimes of local groups were pretty much pushed under the table, and there was no, as far as I know, I'm not aware of any big trials which took place. But there is no way how the Second World War could be connected to the war in 90s, because it's but the crimes which happened were misused by new nationalists just for the cause of shaping the country by the way in which was explained by Nena. You couldn't reshape the country without making a case, and some events from Second World War were misused to just provoke a nationalist and to spread the nationalism.
Thank you very much, Nena. Yeah, in this order it should be Geoffrey, of course. My apologies.
I'll stand just because I can't see everybody otherwise. The first and third questions really require almost a similar answer, because in each case it has to do with the power of the Security Council or its permanent 5 members to block progress. So you ask the question, when will something like the Rohingya Muslims or others find themselves properly respected in international organizations? Well, the answer is if and only if the people with overwhelming power decide that should happen. The International Criminal Court covers a small part of the world and is not signed up to by the big countries. And until they do that, until it becomes a universal court, the court here has an uncertain future, and it can't necessarily serve the people for whom you are particularly concerned. And of course, so far as the people of Srebrenica is concerned, it can't serve them either. And poor Bosnia, I shouldn't categorize it in a patronizing way, but Bosnia is in the unfortunate position of being the recipient of a very unsatisfactory judgment at the International Court of Justice 9 3/4 years ago, where Bosnia more or less lost every point it sought to make against Serbia in an allegation that Serbia had breached the Genocide Convention. And Bosnia is not really in the position to put that right unless it really takes some very dramatic steps in the very near future. And nobody else is ever going to put right the record of Bosnia's suffering at the hands of Serbia as opposed to the hands of individuals, because that's not the way the world works. And one of the, if I can say 2 more points before I sit, one of the sad things that victim groups have to understand is not only that they're not that well regarded by courts, they're always the bottom interest. It's a funny thing to say, but victims are the lowest interest, really, in the sense that they always yield to another interest, to the law, to the prosecutor, sometimes to the perpetrator. And what's more, there's nobody going to do their job for them. Unless they can find a way of having a voice, then I'm afraid history will be written without their having the benefit of fairness. But I also want to say one other thing, in particular perhaps to deal with Thomas's point, because if it was left as a sense that most of our commentary was negative, that would be wrong. And one of the reasons it would be wrong is that people like me, mere lawyers, thank you for the nice things you've said about me, but I don't deserve them. I've never, genuinely, I just did an interesting job in a very comfortable city. And I've never been a victim. And therefore my perception of the interests and the responses of victims to what the tribunals have done might be quite wrong. I might think, oh, what they really want to know is the truth of what happened. Whereas in fact victims might really want to see people convicted. And if that's what they want, Thomas, then the tribunal has in many cases been very successful. But that's not something I can deal with, because I only speak about that second hand. Gordana and others can speak about it first hand.
My question is not answered. My question was, what happens to the international community and the capitals when there is something happening, against the Muslims? May it be the Rohingya Muslims, Bosnian Muslims, Al-Habja, Iran, or Kashmiri Muslims. What happens to them? You know, what sort of human rights championship is this, that you have selection? If something happens to one single lesbian or homo, there will be noise. All
well, all right. Let's not categorize the world too much, because I'm going to give you an answer that I hope will cheer you, which is that Nena may be able to point you in her book to a disturbing conclusion from her analysis of the trial record that shows that there is indeed merit in your concern that some of the choice against legal action is rather like some of the choice against military action in the Bosnian conflict, which is choices being made against Muslims. But I'll let Nena deal with that.
Thank you. And finally, Nena.
Thank you, Sir Geoffrey. This is the most difficult part of our subject matter, but you can't argue with a courtroom lawyer. Yes, I can, yeah. So the ambassador, she just left? Is she coming? Okay. Thank you for the questions and welcome to The Hague. Talking about this, one-liners of expectations, you will all remember this sort of one-liner, there is no peace without justice. Yes, there is, of course. We haven't known anything else in the past. That was always Victor's justice. It was imposed social order dominance, political dominance, and this is how we lived. And now only recently there is expectations that after wars we wouldn't have any victors and losers, and that we will find some sort of way forward, and justice system of international criminal justice regime will be there to sort it out, and for losers, military losers, political losers side, and for whatever other victor side can be. And there is another one-liner which is interesting. There is no justice without truth. How could we have a justice system as we were having now for 25 years of the work of tribunal, which you might have detected all three of us are very positive about. And this is an interesting contradiction, because we all agree that without tribunal, post-conflict situation in the Balkans would be very different. So we do see that it was a changer, that it was a great contributor to some social and political dynamics. Maybe even the most valued thing about tribunal would be that it brought some sort of stability. And what if you study this subject matter of mine, you have to study and tribunal, international community, and all things related. You do come to conclusion that there is discrepancy between what was intended mandate of tribunal, which was probably overreaching big time the real capabilities, but there are unintended benefits that we are still busy to articulate. And my modest contribution to that was this book, because I fought against all odds just through all this maze of proclaim intended purposes of tribunal to find answer, common sense answer to myself. What have I been doing 6 years? So in 300 pages I explained, so it was obviously very little. But these unintended purposes, goals, achievements are still there for all of us to identify and to share with the rest, because we will need them. We will need them for every of these upcoming or current problems we have now. So yes, peace is possible without justice. Yes, justice is possible without truth. But now that we know these notions, we obviously as civilization would like to contribute to both of them. And Sir Geoffrey and I were in Sarajevo exactly a week ago, and we were having at the university this sort of debate, and after debate we had drinks with two immensely bright PhD students. And they told me that they were very thankful to me because I openly talked about Greater Serbia ideology. And mind you, the only thing what I was doing, I was reproducing exhibits from Milosevic case. I didn't invent Greater Serbia, couldn't care less about it, but the trial record is full of physical maps, things that were produced. Some best maps were produced by defense witnesses. And this wonderful young PhD student, she told us, because we are not allowed even to mention Greater Serbia in our academic discourse. We looked at her and said, why? It was almost like Rwanda situation. And another example, they told us that a colleague of them wanted to investigate, is I think sociologist or criminologist, something like that, not lawyer, genocide in Gorazde. You know that there were 3 enclaves, Žepa and Srebrenica were taken over, and Gorazde was not taken over. And their academic community in Sarajevo, consisting mostly of Bosniaks, Bosnian Muslims, they told him, you can't have this topic because we do not have a rubber stamp that there was genocide in Gorazde. We all coming from worlds where academic freedom is so important. We cannot conceive it, but this is actually this post-conflict society they are living in. And we coming from outside, we can contribute, and we should contribute, even if it's just a little book or conference or something like that. Thank you.
Thank you very much. Let's collect 3-4 more questions.
Thank you. My name is Betty Holler. I'm a lawyer in the Office of the Prosecutor with the International Criminal Court, but I'm also Slovenian, so I come from the region, so I feel close to the discussion today. I guess I have a comment and 2 short questions. I guess I'm one of the skeptics in the sense that I think whether, or I disagree really, whether mass atrocities trials can and should be used as a tool to control historical narrative. And I guess one of the reasons is that as prosecutors, I guess prosecutors have different objectives that they follow as opposed to historians. And a part of that is that when we write indictments, the crimes we charge are, of course, often selective. A prosecutor in any of the international tribunals will tell you, you don't charge every single crime that was committed in an attack. And that I feel that then shapes the narrative of that event, and it's not necessarily the correct narrative or how the victims of a particular event perhaps have felt it. So again, I'm skeptical in that sense. Then then I have two questions. Sorry if I'm a bit long. My first question is that we've heard twice that the adversarial system is not the best way to perhaps determine the truth. And I'm wondering whether what we would term an inquisitorial system for the international tribunals, would that go a longer way or not? And then I have a question for Ms. Knežević, and she mentioned that the people in Bosnia, they don't read the judgments or go through archives. And I'm wondering whether there's any difference in attention towards the decisions of the Bosnian State Court or the war crimes chambers there. I guess in the sense of whether those national trials, the role they play in shaping a historical narrative in comparison to the international trials, if there is any difference. Thank you.
Thank you very much for your presentation. I'm an intern at the Appeals Chamber of the ICTY right now, so I can offer some perspective from the trial chamber itself. I also share the previous commenters' view, saying that they have some skepticism over the position that the trials should be used as a tool to control the truth. Because when I was hearing your presentations, three presentations, I felt that you were speaking of a pure historical truth. But from my job I've been doing, I felt that every time when the chamber is facing evidence, exhibits, they are having to deal with all of them under certain of legal standard. For example, JCE3, when we are trying to shape the image of the incidents and the role of the accused in that incident, we don't know what's really happening there. We just think that, okay, there is substantial likelihood that he is predicting that thing is happening, so he should be responsible for under JCE3 for that crime. So there is, I feel that nobody knows that if he or not he should be responsible for that incident. There's no purely historical truth, but I don't know if I understand you wrong or not, but it might be pleasure if I can have more perspectives from you. Thank you.
One more question? Then.
Thank you both very much for the question about title, and I am very grateful that you drew my attention that it could be misunderstood. The title was actually a variation of the fact that there was this initial conception and understanding that criminal trials will be, mass atrocities trials will be greeted by all involved parties as a wonderful way to and punish perpetrators and deliver justice for the victims, deter further crimes, contribute to reconciliation and to exposing the truth. What we have understood in these transitional justice studies is that not all parties involved in the process use legal processes for legal purposes. There are parties involved in a legal process that will try to control the process, not always and necessarily to manipulate historical truth, but for example, you have post-conflict regimes that it will willingly extradite so-called perpetrators just to get rid of them. You know? So what that fact tells us, and how does this fact contribute to fullness end of trial record of historical interpretation? Another thing is the former Yugoslav states, especially Croatia and Serbia, were compelled by this UN court to cooperate, and there was a stick and carrot mechanism applied. If they cooperate, they get a carrot. If they don't, they get punished. So in this process, their cooperation was not only half-hearted, but very manipulative. And they would try to avoid to hand over and fugitives and documentation. So the title actually tells us that, yes, even if mass atrocity trial has been conducted with all involved parties having only the justice at heart, historical interpretation might be problematic because of all these things like inadequate indictment or guilty pleas. You know, you would have indictees who would admit everything to, and you would have others who would have guilty plea arguing only this part should be in, and so forth. But the title referred to the fact that in post-conflict societies, at mass atrocities trials, you will have parties involved in the process, especially the states, who would do everything to avoid the complete and full cooperation with the legal system, but would hold facts, evidence, all sorts of things away from the court. So the title refers to those interventions. And I'm sorry that you misunderstood it, and I will certainly correct it next time to make it more clear what it meant. Thank you.
The adversarial system's the only one that's been tried so far, so we simply don't know. For my part, I'd really like to see a trial tried in another way. Adversarial trials are huge fun for the lawyers. You get paid to go and play a game and beat up witnesses. Do all sorts of horrible things which are really gratifying. They're not very much to do with the truth very often. So yeah, why not? Let's try another system, but nobody ever has. And do you know why we have the adversarial system for all these trials? It was an act of cultural imperialism by America and Australia and England. It wasn't, nobody made a calculated decision, this is the best trial system. And since it's a trial system that is completely alien to the people of the former Yugoslavia, and they often find some of its processes offensive, you can raise other arguments for saying that really another system should have been tried. But I do think it's also quite important to make this observation about the adversarial trial system, picking up on what Naina's just said. The horrible reality is that there is no state that will ever own up to anything, tell any truth, if it's not in its interest to do so. And so to state somehow that set up these courts, the adversarial system, which is aimed at fighting and keeping information to yourself, somehow fits with their general amoral approach. And it really is an amoral approach, the way states hide everything from us. And I'm going to indulge myself by 1 minute of a hobby horse. You may think, oh, he's just a old-fashioned, unreconstructed something or other who just loathes all powerful bodies. Well, maybe I am. But just think about this for a minute. In domestic criminal systems, and also in the ICTY and the ICC, there's some kind of hope that people who are guilty will own up, tell the truth, plead guilty. It's not quite clear why people are expected to do that. It may be because it shows contrition, or maybe because it's cheaper for the administration of justice. But that's what states ask of people they introduce into their criminal justice systems or their international systems. And yet states themselves will never own up. What a strange clash of cultures it is between those who rule us and those who enter the systems that are created by those who rule. And I believe that slowly emerging from this mess, and it is a bit of a mess, although I'll come and I hope say something that will cheer up the intern from the ICTY in due course. But out of all this mess, I wonder if the thread that we may be able to draw is the thread that the public are beginning to draw when they say, actually, you know, we have a right to know. Forget your complicated systems, your silly adversarial games, your judges in funny clothes. We actually have a right to know. You, Serbia, do not have a right to lock up your files on what happened to us. You, United States and England, Canada, whoever it may be, who held back those intercepts of Milosevic and Mladic, you don't have a right to keep that, because we have the right. And it's time, and it's slowly happening, maybe assisted by people like Assange and all that sort of thing. It is slowly happening. We have a right to know. Whether the adversarial system or the inquisitorial system would take us there more quickly, I'm afraid. I don't know, because it's never been tried. And as to the dissatisfaction with what happens in the criminal process, because it's not as good as getting the truth by some other method, I think the answer has to be that it's better than nothing. And that although the process is strange and it's limited and it's got a very narrow focus, we really have in these trials, and Mirko at the back, who's seen them all, knows better than anyone else. We have, Mirko Claren sitting there, we have seen an immense amount of material produced for news and other organizations to broadcast that would never have been available. Some of it can be analyzed in Nena's book, much of it in all sorts of other ways by Gordana and others. And the only thing I would add, because it's about the last time I shall speak, I expect, I hope, the point that might have been made in response to the question 2 questions ago, one of the deductions that Nena makes by standing back and looking at the evidence in her book has to do with the motivation of the West towards obstructing the creation of a Muslim society in the heart of Europe. But you'll find out more about that if you read the book.
Okay, I can answer the question to compare the war crime courts in the region with international tribunal like the Hague Tribunal. It's unfortunately until now the local courts didn't show strength and they are even less effective, and they have less they have less influence and they have less respect compared to international court, because what is happening, it's because patriotism and nationalism is very much mixed with their work. And it's, for example, only recently, I think it happened just at the beginning of this of this week, 8 people were charged by war crime tribunal in Serbia, local court, for genocide in Srebrenica. And even this first appearance was not successful, you know, like this was, and nobody knows in which direction this case would go, you know, like, and it is not seen as, you know, like, it's, and I mean, after such a mass murder committed, and I assume that most of people who committed crime in Srebrenica now live in Serbia, and after so many years, first 8 people are being charged. I mean, that's the shame of local courts. The other thing which is happening with local courts is as well, they pick up the wrong subjects. They pick up the wrong people. For example, a Serb general who managed to get the army units from Croatia without a single bullet being fired, he was charged by Serbian courts and by Serbian war crime courts for years. His title was taken away. He was mistreated. He was, you know, like, and it's only recently that he managed to recover his name and to recover his, you know, but he's destroyed man, and he's destroyed. He was, instead of being declared a hero because he bring all the army back home without fighting, he was seen as somebody who betrayed. The other example is the General Barovic. He was general in charge of in Pula, Croatian city, and he promised that he won't shoot to Croats. He promised that, and he said, if I'm ordered to do so, I would rather take my own life. So when he was ordered to shoot Croats, he took his own life. First of all, news about this was killed and was not known in former Yugoslavia. The other thing is he's seen by somebody who betrayed his duty, his army, his national ranks, this man for me is a hero. The other thing is as well, Serbia issued indictments against two people in Bosnia. One of them is General Divjak, the other one is Ganic, a member of Bosnian presidency. I mean, and both these men, one was detained in London because of Serbia issued an international warrant for him. The other one was detained in Vienna. Those indictments were totally unfounded, and these guys both spent some time in detention, and it took them a few months to prove that they are not war criminals, but that they were just doing their duty during the war. It's again, so with this criteria and with this system of values, you cannot have the right war crime tribunal in your own country, unless because if your court is established on the idea that you have regrets that you didn't win the war, and that these people, you charge people of whom you think that they didn't help you in this war. On that assumption, you cannot have a healthy war crimes trials.
Wow, thank you, Gordana. It was a very persuasive argument. And as Sir Geoffrey encouraged me to talk about, I think, most challenging conclusions of my book, I am a little bit concerned that we will end this otherwise very interesting and pleasant evening on a quite unhappy, disturbing note. But I will tell you what actually happened. While working on Milosevic case, I didn't have so much time for any bird perspective on what I was doing. It was, regular, everyday, long hours, and so forth. And starting writing book and having to be very economical about book, you have to have a laser and mind and courage to pick up your topics and battles. So I made the bone of contention of my book doing leader, ideology, and the plan separately. And while doing the plan and using actually all the maps we had used during the trial, I put these maps next to each other, and unfortunately I didn't put it on PowerPoint because we sort of agreed that we would not use too much of PowerPoint, but it's a very powerful image. And so I connected three different things. After I finished book, actually, I was rereading, re-editing. And there was a moment of panic. I called Sir Geoffrey and my other very good friend, Sonja Biserko, and I told them, well, I must be losing my mind, but what I found here is very strange, but it fits into something that I never considered before. So what did it fit? First of all, we had quite amazing evidence coming from high-level witnesses telling us that international community did encourage and Croatia and Serbia and their leaders to partition Bosnia, because some powerful European politicians didn't want Muslim majority state in the heart of Europe. So it was beginning of the end of the Cold War. Second thing that I discovered was that if you go through this developing criminality from the Serbian side, that from December 91, one of their major goals, proclaimed, written down, actually published in official gazettes, was ethnic separation. Okay, we don't have a map. And there was this rumor that there was a meeting between Milosevic and Tudjman, Croatian president, in March '91, when they agreed about partition. And interestingly, again, if you go back to transformative value of trial evidence, can you imagine we having witnesses from both sides, prosecution witnesses and defense witnesses, and Milosevic being his own lawyer, asking them questions, and they discussed Karađorđevo, and yes, Karađorđevo did happen, and yes, both of them discussed partition of Bosnia, and yes, they were telling everyone Bosnia will fall with a whisper, because international community would support it. And when I put together all peace plan maps for Bosnia, that was the moment when I called Sir Geoffrey and Sonja Biserko. I saw that international community's first peace plan, Kutliero peace plan, for February '92, before war in Bosnia started, already ethnically divided Bosnia in clusters. And Bosnia was like tiger spots. So suddenly I realized, yes, ethnic division and separation was the goal, that Serb goals coincided with international community goals. And the third part of this puzzle that completely amazed me was that if you look into each of the Yugoslav republics before '91 and ethnic composition, you would see that they are very color mixed. Each of them, after the wars, became ethnically homogeneous like never ever before in the world, in the history. So ethnic separation and ethnic homogenization appeared to be also unstated goal by international community, because there is no other way they would support these peace processes. And that was, I think, unhappy note, because why it is unhappy? If we have our democratic countries acting in international arena on behalf of us, what do you want? We want transparency. We want them to tell us, their voters, what they are up to. But they never stated these things for us to consider and give us a chance to vote or outvote them out of power. So we live in a quite interesting and to very high extent, to very great extent, unsettling world. And we need more transparency.
Thank you for concluding the evening on somewhat positive note. Before we round up, I wanted to say very briefly two things. This is not the last lecture in the series. Please follow us for updates on the webpage. Feel free to subscribe for the newsletters. Also, we hope, and we will discuss it with the speakers, to make this lecture at least partially available on video, and further on the links will be illustrated. Well, thank you very much to the audience for making it to the ELSA Institute at such a late hour, but most importantly, thank you for our outstanding speakers for, may say, very fascinating presentations.
Were you nervous? Were you nervous?
First time